All right. This is just We the People of News, okay? Now, I'm going to be plain out blunt and honest with you. I'm not an attorney. I'm not here to give you legal advice. I'm giving my opinion, okay? With my little knowledge. But this is what I see in this wide world, okay? Now, we talked about these people right here, right? And how Congress does not take responsibility for their actions or what they create, okay? Let's go with an easy way of saying this, right? Congress wants me to create rules and statutes against these people right here and FBI agencies and all these other agencies that they are no longer allowed to wear a blue shirt because they don't want colorblind people to be insulted. Okay, it's just a figure of speech, right? And to make it simple and sweet of what these people are doing. Alrighty. Okay, so I get up in there. Now, Congress wants to pass a law because apparently they just have something against blue shirts, right? They want to pass a law saying that nobody in the United States are allowed to wear blue shirts. Okay? We the people are not allowed to wear blue shirts. These people are not allowed to wear blue shirts. So they call me in the office, right? And I say, okay, we cannot create a law that nobody's allowed to wear blue shirts because that'd be unconstitutional. Okay? So, Diesel, you gonna have to come up with some way of forcing where nobody can wear a blue shirt. Okay? Alrighty. So, what I do is go out there and create a rule and statute saying nobody's allowed to wear a blue shirt. Well, there's going to be somebody out there saying, well, that's unconstitutional. But I am not Congress. Okay? I'm a side effect of Congress. I'm a bypass law Congress. Okay? I just going to bypass the Constitution because I'm not part of Congress. Right? And I'm going to charge you $50,000 for wearing a blue shirt. So the guy or woman takes it to the Supreme Court. Well, we go to the Supreme Court. Well, what is the reason that these people cannot wear blue shirts? Well, Your Honor, a lot of people out there are colorblind. So when they see a blue shirt, it's going to be a green shirt. And they see green so often that it causes them mental anguish. So therefore, we cannot have all these people with mental anguish due to other people wearing blue shirts. So therefore, we need to keep this active. Okay, well that sounds reasonable. So the Supreme Court says, okay, well, sorry y'all. It's within Diesel's authority to go ahead and you must pay that $50,000 for wearing that blue shirt that they made a rule that you cannot wear. Case dismissed. This is how twisted it has become, y'all. And I'm just using a very simple thing about it, but in essence, that's what it is actually doing. And then you guys are going to get mad at Congress. Well, Congress is going to stand back. Oh, no, it's not my fault. It's Diesel's fault. He's the one who came up with the rules. Bypass. Okay? Just like the president has no authority over these people, right? However, because as big as cowards Congress is, they actually gave authority to the president that the president does not have. Why did they do that? Because presidents have 4 to 8 year terms, right? Congress is allowed to be voted in for the rest of their lives. So we're just going to let the president take the fall for us, and blame it all on the president. We're under the illusion the president has all these magical powers that he doesn't have. But the only way he has it is because Congress was too much of a coward to be responsible for their own actions. So this pushed it off on the president. That way, when he's voted out, it still keeps going on. And we're all mad at the president. But nobody's mad at Congress. So therefore, Nancy Pelosi gets to stay in forever. Tim Cruz gets to stay in forever. Biden got to stay in forever. And because we all blame the president. Because Congress gave away their authority to the president to take Congress responsibility. Oh, by the way, the reason why you're not represented in a proper manner is because we're supposed to have 11,000 congressmen right now. But because they were too much of a coward to take responsibility of we the people, it was easier to be only 436, I believe it is, right? Which is way overwhelming of people that they're supposed to represent. So what do? They pick 5 people out of there, in short, and say, hey, what do you want me to do? What do you want me to do? Okay, that sounds reasonable. Well, we're going to go ahead and do that. By the way, you're going to pay me off. Meanwhile, the rest of maybe 100,000 people, 500,000 people, whatever the case may be, right? Let's go with Houston. Okay? Houston is supposed to have what? If it's 1 million people, 30,000 for every congressman. Houston's supposed to what? You guys do the math, but they have to every bit of what? 100 congressmen just in the Houston area? That's how many we're supposed to have in the Houston area, people. There's 11,000 congressmen. That way we can call Congress and say, knock your crap off. And we wonder why that when we call them, they don't never call us back. Because they're overwhelmed. Well, they shouldn't be overwhelmed because there's only supposed to be 30,000 of us and not 1 million of us. Just saying. That is actually in the Constitution, and they just violated the Constitution. They also violated the 12th Amendment Constitution that the president and the vice presidents are on 2 separate tickets. We're supposed to vote for the vice president, not the president, y'all. And that's never been changed. We're under the illusion that we vote for the president and the president gets to pick. No. They're allowed to be a Democrat vice president with a Republican president. And that would make our jobs a lot easier and they wouldn't get by with so much crap. Just saying, y'all. If you don't think they're not violating constitutions left and right, pay attention.
Sorry for the easy one. So one of the big, you mentioned the CRA earlier, one of the big, in my mind, steps of progress during the Trump administration is the application of CRA to separate regulatory budgets. And we saw a number of resolutions of disapproval go along those lines, and also extended it to, and made it clear they were applying to independent agencies, some banking regulators, for example. The CRA starts by saying, before the regulation can go into effect. So just sort of tying, it must be submitted to Congress, which is very different than the timetable that Congress has to act on a resolution of disapproval. In theory, that's open-ended. So my question is, I'll give you a hypothetical. During the Trump administration, the PTO issued the director a series of guidance to examiners on, for example, about patent eligibility, but on a number of other issues. None of that was submitted to Congress. So the first question is, under a literal interpretation of law, are those legitimate rules? Are they in effect? The statute is simply clearly not. The second question is, and this gets judicial review, what are the implications for that? For example, if you get an adverse result as a result of regulatory action that is not legal because that's not compliant with CRA, do you have judicial recourse?
Paul, I know you dealt with this question on a couple of key issues that came up in your tenure, so I'll turn to you first.
Great. Well, yeah. So as I recall, and I haven't looked at the issue in a couple of years, that I don't believe that any courts, or at least not many courts, have found the failure to submit reviewable.
Although it won't surprise you to know that there are some in the Ninth Circuit that disagree with that.
I'm shocked to hear that. So really, I would say that that's the principal question there. And as the case law continues to develop on that question, I think that it will assume greater and greater significance.
My first question is, how is that an easy? My impression is the same as Paul's, but I know that that has been a subject of oversight. And to the best of my recollection, Senator Grassley in particular has been very interested in compliance with the submission of the major rule designations and their accuracy. And so I know we had to do some work to make sure that the executive agency family is fully compliant.
The only thing that I would add is that, we talked about, of course, everyone knows the judiciary's primary job is to interpret the law. Both Paul and Boris have talked about how they operated in terms of trying to interpret the law and their roles. But we can't forget that Congress also has an independent responsibility, believe it or not, to interpret the laws. And the Congressional Review Act is one example of that. Because an agency that is part of Congress, the CBO, frequently is called on.
Same thing about that. Congress has a right to interpret the law. Well, aren't they lawmakers? Aren't they supposed to make the law? Just saying. That's what we call them, right? Lawmakers. So why are you interpreting something that you're supposed to be making a law? P.S. All right. 98 laws out there are not actually passed by Congress. So they're not even actually law. For example, Title 18 USC is a positive law. Congress passed that. Okay? 42 USC is not a positive law. It was never passed by Congress. Okay? Title 42 is run by these people. Okay? And 42 is a violation of the rights, y'all, by the way. Okay? And if you, just an example, okay? Title 48 or Title 42 is within the guidelines of the 4D Program Child Support Agency that the magistrates and the district attorneys and all that are signed in a contract with the state and the county against the mom and dad. There is no due process. Why? Because 48 title is not positive law. So what most parents do is actually enter a contract. Now it made it legal. Just that simple, people.
To determine whether or not something an agency has done is subject to the Congressional Review Act. And there have been disagreements between the executive branch and the legislative branch over whether sub-regulatory guidance in particular, I can think of with U.S.
Why is there a disagreement? Isn't Congress supposed to be the bosses? Just saying.
Individual forest plans are subject to the Congressional Review Act. And, ultimately it's up to Congress what laws are passed. So even if the executive branch says, we don't think this is subject to the CRA, Congressional Review Act, if Congress does think it's subject to that, and they pass according to its procedures a resolution of disapproving of something, the text of the CRA would seem to make it very difficult to challenge Congress's determination that this is something that should be subject to the Congressional Review Act. So that's kind of an example that we don't often think about because everyone thinks the judiciary is the final
But that being said, if Congress don't pass it into law, these people can still act it as if it's law. What do we all call it? Color of law, people.
Well,
Word on what the law is. But in this case, Congress itself may have the final rule as to what comes within the ambit of that particular piece of legislation. I know we had a question over here, so I want to go to you and then we'll go around.
So, picking up on the last point you guys were making in the discussion, on the adjudicatory function that OIRA serves with disputes among the agencies. Chevron deference is premised on the idea of agency expertise. And in the OIRA review process, sometimes the agency submitting the rule can get a bit bloodied and bludgeoned. And what goes in is not what comes out. So, in your view, to what extent does the OIRA process either support or undermine that notion that the agency, in its final rule or its subject to judicial review, should get deference because of its expertise?
Horace?
That's a great and somewhat much debated question. I think I think the adjudicatory description of what OIRA does is probably a more heuristic more than anything else. I think it is in fact closer to something like a mediation function. Because it behooves everyone in the executive branch family ultimately to get along. Otherwise, the president's going to spend a whole lot of time trying to make tough decisions that the agencies can't make by themselves. And I think the OIRA administrator is more of a facilitator of those decisions. There's no doubt, though, not to evade your question, that there's substantive input that happens during the OIRA process. But I think the ultimate authority to agree to the results of that process and the ultimate authority to issue rule, the rule resides with the agency head, and I think everyone will ultimately say that's whose final call it is, and that's when the deference adheres.
Paul?
yeah, and it's a great question. So
That'd be for the agency to decide, people.
So the agency has a kind of expertise. I mean, every agency has a kind of expertise that can really benefit from the dialogue with OIRA. Right? So, well, I imagine all of you could testify to this from personal experience. I think everyone in this room has some sort of expertise in something or other. Imagine that an interlocutor who knows, something about your area, maybe less than you do, were to engage in a dialogue with you. Well, probably your thinking would be sharpened, even within the domain of your expertise from that conversation, from having to explain to the person you're talking to why the conclusion follows that you assert follows, right? So I think really OIRA review tends to kind of bring fully into play agency expertise, right? There's at least two kinds of expertise we can think about. There's the expertise that's sort of like a muscle memory expertise, right? The expertise of a 4-year-old riding a tricycle, right? Maybe the 4-year-old isn't able to articulate what it means to ride a tricycle, how she knows how to do it, but she does know how to do it. Then there's the expertise that lawyers have, which is a kind of expertise that is susceptible of being explained, and that's the kind of expertise that agencies have. So there isn't really a good reason that an agency wouldn't be able to fully explain the bases for its expert conclusions to OIRA. And so I think for that reason, OIRA review is both fully consistent with and indeed in aid of agency expertise.
Well, if I could beg, I know there were a lot of questions. We could just do one more question. I think 3 is a good number.
I think we're going to stop it there, y'all. All right. This will be the People News. Bye, y'all.